Let's take a look at accommodations from an employment law perspective. Protection against discrimination means little to disabled persons if workplaces remain full of barriers that effectively preclude employment. Sometimes these are physical obstacles, such as the absence of wheelchair accessibility, but more often, inflexible policies and practices persist. Likewise, employers with requirements, such as schedules or appearance standards, that conflict with the sincere religious beliefs and practices of employees place them in the untenable position of choosing between their jobs and their faith. In mandating reasonable accommodation of disability and religion, the law requires employers to be more flexible than they might otherwise be, provided that accommodations are reasonable and do not impose undue hardship. The obligation to reasonably accommodate is unique to protected classes of disabilities and religion. However, the legal basis and nature of this obligation differ depending on whether disability or religion is involved. It is also more difficult for employees to establish entitlement to reasonable accommodation for their disabilities than for their religious beliefs and practices. The obligation to reasonably accommodate disabled persons is more extensive than requirements to accommodate religion. The obligation of employers to reasonably accommodate disability arises under two similar laws, the Americans with Disabilities Act and the Rehabilitation Act. The ADA was explicitly modeled after the Rehabilitation Act, which covers federal government agencies and federal contractors. We will focus on the ADA because its broader coverage, which is private sector employers with at least 15 employees, including state and local governments. The ADA protects a qualified individual with a disability from discrimination because of his or her disability. The essential premise of the ADA is that people can have disabilities and still be quite capable of working, particularly if flexibility and support are available to them. Although some legal definitions of disability are based on the inability to secure employment, the view of disabled persons under federal anti-discrimination laws is very different. The definition of disability under the ADA includes the following: a physical or mental impairment that substantially limits one or more major life activities, a record of having such an impairment, or being regarded as having such an impairment. An employee is protected under the ADA if they meet any of the three criteria. There's no protection for non-disabled persons who are discriminated against because of their association with disabled persons. Although this definition appears broad, plaintiffs have difficulty getting past the threshold issue. Prior to the enactment of the ADA Amendments Act, the ADAAA, in 2008, courts found many plaintiffs to not be disabled despite their epilepsy, diabetes, depression, and a host of other conditions typically viewed as disabilities. In amending the ADA, Congress declared that the definition of disability under the ADA shall be construed in favor of a broad coverage of individuals under the Act. However, although the ADA Amendments Act makes it easier to prove a disability, it does not absolve a party from proving one. Both physical and mental impairments are incorporated into the definition of disability. It's critical to realize that not all serious health problems meet the legal definition of disability. The definition of disability is based on an individualized assessment of the effects of health problems on a person's functioning rather than on a diagnostic label. Although the ADA does not list specific impairments that are considered disabilities, the Equal Employment Opportunity Commission has identified impairments that should easily qualify as disabilities, though the list is not exhaustive. Physical disorders like deafness and blindness, neurological conditions like autism and cerebral palsy, psychological disorders like bipolar or schizophrenia, and other conditions like cancer, muscular dystrophy, diabetes, and depression. The list is not exhaustive. Many other types of impairments can be disabilities. Certain conditions or behaviors are expressly excluded from the definition as well. Significantly, persons who are current users of illegal drugs, regardless of whether they suffer from drug addiction, are not considered disabled under the ADA. However, those undergoing rehabilitation for drug addiction and are not currently using illegal drugs are protected by the ADA. To be considered a disability, a physical or mental impairment must substantially limit an individual in the performance of one or more major life activities. Major life activities include, but are not limited to, caring for oneself, seeing, hearing, eating, sleeping, walking, standing, sitting, reaching, lifting, speaking, breathing, learning, reading, and communicating. The third component of the definition of disability is that the individual must be substantially limited, but not necessarily completely unable in the performance of a major life activity. The central issue is whether, compared to most people in the general population, the individual's impairment substantially limits the conditions, manner, or amount of time it takes to perform a major life activity. The focus is on how tasks are performed rather than on which outcomes the individual manages to achieve. Disabilities are often long-standing conditions or expected to have a long-term impact on functioning rather than acute injuries expected to heal relatively quickly. However, a condition that is episodic, that flares up unexpectedly, or is in remission still continues to be a disability if it would substantially limit a major life activity when active. Importantly, the determination of whether an impairment is substantially limiting must be made without regard to the effects of mitigating measures. Supports that disabled persons use to manage their disabilities include things like medications, prosthetic devices, hearing aids, implants, mobility devices, oxygen therapy, equipment, and learned behavioral adaptation. The assessment of whether an impairment is substantially limiting must be based on the nature of the underlying condition rather than on how well the person is able to cope despite their condition. Mitigating measures do not include ordinary eyeglasses or contact lenses intended to fully correct visual activity. Employees are sometimes discriminated against not because they're currently disabled or in addition to that, but because of a prior disability. This type of discrimination might occur because of the stigma associated with the condition, like drug addiction or mental illness, or fears that the condition will reoccur. Sometimes people are misclassified, like being learning disabled, and the record of erroneous diagnosis stays with them. Persons who have a record of a disability, whether because of their medical history or misclassification, are protected under the ADA. Persons who are erroneously regarded as being disabled are protected by the ADA. Many stereotypes, fears, and misconceptions exist regarding people with disabilities. People might be regarded as disabled because of unfounded rumors, or, as is more often the case, because conditions they have are assumed to be much more limiting than they really are. This definition of disability is satisfied by showing that the plaintiff was subjected to discrimination because of an actual or perceived physical or mental impairment, whether or not the impairment substantially limits a major life activity. However, the impairment must not be transitory, an actual or expected duration of less than 6 months, and minor. It is important for managers to have a clear understanding of any medical restrictions placed on their employees before making decisions about their suitability for employment opportunities. People who are regarded as disabled are protected from discrimination, but unlike those with an actual disability, they're not legally entitled to receive reasonable accommodation. To be protected under the ADA, individuals must not only be disabled, but also be qualified. A qualified individual with a disability satisfies the skill, education, experience, and other job-related requirements and is able to do the job, with or without reasonable accommodation, to perform the essential functions. An individual who can perform the essential functions of a job, but whose condition is such that she poses a direct threat to the health and safety of herself or to others, is not considered qualified. A direct threat is something that cannot be eliminated by a reasonable accommodation. Jobs consist of bundles of tasks. Some of those tasks are central to why the job exists, others are more peripheral. Under the ADA, a disabled person's ability to perform a job must be judged only in relation to the essential functions of the job in question. Inability to perform marginal functions cannot be the basis for adverse employment decisions. It's important that employers determine the essential functions of a job. The basic criteria for identifying essential functions are as follows. The position exists to perform the function. Few other employees are available to perform this function, and the function is highly specialized. Evidence of essential functions includes the employer's own judgment, written job descriptions, job duties listed in collective bargaining agreements, and statements based on the work experience of job occupants. Tasks that are performed infrequently are less likely to be considered essential, but this is not always the case. The ADA does not require that employers perform job analysis, systematic studies of jobs to document the major tasks involved and the knowledge, skills, and abilities needed for successful job performance, or to have job descriptions. However, the importance of documenting essential functions for compliance with the ADA provides employers with a clear reason to carefully study jobs and document them in up-to-date job descriptions. Job descriptions should distinguish essential functions from marginal functions and specify and state all essential job functions. An employer that rejects a disabled job candidate because he's unable to perform some function that was not important enough to warrant mention in a job description is in a questionable legal position. Additionally, job descriptions and employers deciding whether disabled persons can perform the essential functions of a job should focus on what needs to be accomplished rather than how tasks are accomplished. Disabled persons are often able to devise alternative ways of doing things. Employers should be open to different means for producing the same outcomes, unless there are important safety concerns that require a certain method. Employers must assess the ability of disabled persons to perform the essential functions of jobs with or without reasonable accommodation. To be qualified, disabled persons must meet the same requirements for education, skill, experience, and background that apply to all other job candidates and employees. However, if a requirement screens out or tends to screen out an individual with a disability or a class of such persons, the employer must be prepared to prove that the requirement is job related and consistent with business necessity. Possession of a valid driver's license, a qualification not available to some disabled persons, is a lawful requirement only if driving is an essential function of the specific position. A trucking company could not establish the business necessity of a policy under which drivers who disclosed their alcohol problems and successfully completed substance abuse treatment could not be returned to positions as drivers. Only those requirements that relate to the ability to perform the essential functions of a job are consistent with business necessity. Employers sometimes identify individuals as unfit for employment because their disabilities are thought to present a direct threat to safety and health. Such individuals can perform the essential functions of jobs in question, but for reasons such as contagious natures of their conditions or the episodic and unpredictable characteristic of their conditions, pose a substantial risk of harm. An employee who had worked in oil refineries for years and who sought employment at a refinery was rejected because of a liver condition that might be worsened by contact with toxic chemicals. The Supreme Court ruled for the employer, holding that substantial risk to the employee's own safety or health, as well as that of coworkers and customers, falls within the meaning of a direct threat. However, to establish that a person's disability constitutes a direct threat, the employer must show that the employee currently possesses a specific risk of significant harm. This judgment must be made on the basis of objective medical evidence, not on stereotypes or fears. Although the employer usually bears the burden of proving that an employee's disability poses a direct threat, that burden may shift to plaintiffs to show that they will not endanger others in cases involving jobs with public safety functions. Threats to safety or health need not be as certain if the potential consequences are severe. The extra flexibility and support to which qualified individuals with disabilities are entitled serves several purposes. They range from ensuring equal employment opportunity by enabling full participation in the hiring process, enabling performance of the essential functions of jobs and equal enjoyment of the benefits and privileges of employment. Examples of reasonable accommodation specifically mentioned in the ADA include the following: making facilities accessible to and usable by disabled persons, like removing physical barriers, such as narrow aisles or deep carpeting that hinders wheelchair use. Restructuring jobs, like redistributing marginal functions or allowing tasks to be performed in alternative ways. Devising part time or modified work schedules, like flexible start times or liberal medical leave policies. Acquiring or modifying equipment or devices like telephone amplifiers, voice recognition software, or a telephone headset. Adjusting or modifying exams, training materials, and policies, like providing training materials in large print, allowing guide dogs in the workplace, or altering emergency evacuation procedures. Providing qualified readers and interpreters. Finally, reassigning disabled individuals to vacant positions. Not all disabled employees require accommodation. When accommodation is called for, employers are not left to their own devices. Many governmental and non governmental agencies can provide advice and assistance to employers seeking to accommodate disabled employees. Disabled employees themselves are usually the best sources of information regarding their needs and what will work for them. Employers that become aware of a disabled employee's need for reasonable accommodation must engage in an interactive process aimed at identifying an appropriate and mutually agreeable accommodation. Disabled employees should be involved early and continuously in the process of identifying and choosing accommodation. The EEOC has suggested a simple methodology for this interactive process. First, the job in question should be examined and its essential functions determined. Second, the individual with a disability should be consulted to determine specific physical or mental abilities and limitations. Third, together with a disabled individual, potential accommodations should be identified and assessed. Fourth, an accommodation that serves the needs of both the employee and the employer should be selected. In general, disabled employees or applicants are responsible for making employers aware of their need for reasonable accommodation. Such notification need not be in writing, nor is it necessary for the employee or the applicant to say the magic words reasonable accommodation or ADA. The individual just needs to indicate problems with doing a job or complying with other employment requirements and link this difficulty to a serious health problem. Thus, it's critical that managers listen carefully to employees and recognize when an accommodation is being requested. Also, where the need for accommodation is obvious because the individual's disability is visible and his difficulty in performing essential functions of the job is apparent, the employer should initiate a discussion regarding accommodation. The obligation of employers to reasonably accommodate qualified disabled persons is ongoing. Whether an employee requests accommodation when hired or has received other accommodations in the past doesn't matter. Nor can employers arbitrarily decide that they have accommodated employees long enough and discontinue accommodation. An employee who had been accommodated with a part-time schedule for more than 10 years had a valid ADA claim when his employer discontinued this accommodation and fired him. When presented with requests for accommodations, employers should acknowledge receipt of the requests and act on them as quickly as possible. If a disability was previously unknown to the employer, the law allows the employer to require documentation of the need for accommodation. The primary source of such information should be the employee's own healthcare provider. Inquiries from employers to healthcare providers should be restricted to information documenting the need for accommodations and focus on the functional limitations imposed by disabilities. If the information provided is inadequate to assess the need for accommodations, employers can require employees to be seen by another health professional at the employer's expense. Although employers can legitimately seek documentation, care should be taken to prevent requests for help that could easily be granted from degrading into bureaucratic exercises or power struggles. Many employers have policies to guide managers in responding to requests for reasonable accommodation. Under Executive Order 13164, agencies of the federal government must have formal policies to facilitate reasonable accommodation. Reasonable accommodation policies should address how to initiate the process, documentation requirements, and notification of the outcome. Employers must document all aspects of the accommodation process. Like medical information about employees, employers are obligated under the ADA to keep reasons for accommodations confidential. Under the ADA, employers are required to make reasonable accommodation unless doing so would impose an undue hardship. Most often, the interactive process results in a mutually acceptable solution. In cases where an employer's ability to provide a reasonable accommodation is disputed, the exact meaning of the terms reasonable and undue hardship become important. The ADA does not define reasonable accommodation beyond providing examples. Case law and EEOC guidance suggest a number of criteria for the reasonableness of a proposed accommodation. Employers remain free to exceed minimum legal requirements in meeting the needs of employees. The following are criteria for determining the reasonableness of a proposed accommodation. It's effective, it doesn't need to be the employee's preferred option, it doesn't include provision of items for personal use, and it doesn't need to match previous accommodation. Further, working conditions do not need to equal those of other employees. It doesn't require creating a new position. It doesn't require providing paid leave not available to other employees. It does not require eliminating essential functions or lowering standards, does not require excusing misconduct, and does not usually require making exceptions to seniority rules. Employers are under no obligation to create new positions for, promote, or displace, like bump other employees to accommodate disabled employees. However, reassignment to a vacant position can be a reasonable accommodation and must be considered in situations where a disabled employee cannot be accommodated in her present job. Reassignment is Plan B if it proves not to be possible to provide accommodations that will enable employees to perform the essential functions of their current job. There is some ambiguity surrounding the meaning of vacant, but at least one court has held that it would be available for a similarly situated, non-disabled employee to apply for and obtain. Courts have differed in their views of how far employers must go when using reassignment as an accommodation. The EEOC believes that the ADA requires reassignment and not merely consideration in such situations, and some appeals courts have agreed. Other appeals courts, however, have ruled to the contrary. Another significant form of reasonable accommodation is job restructuring. While employers need not eliminate essential functions from jobs to accommodate disabled employees, non-essential functions must be eliminated. Employers are not required to reasonably accommodate disabled employees by permitting substandard performance and misconduct, even if these performance problems are the result of an employee's disabilities. Ideally, such incidents would prompt the interactive process to determine whether accommodation is in order prior to disciplinary action being taken. Employers must sometimes reasonably accommodate disabled persons by providing periods of leave under circumstances different from or in durations longer than the leave normally available to non-disabled employees. But the question of how far employers must go in modifying their leave and attendance policies to accommodate the needs of disabled employees is a matter of considerable debate. Employers are not required to provide paid leave to disabled employees that is not available to all employees. But how much leave must be given before it's concluded that a leave is no longer a reasonable accommodation? How many times must leave be provided anew or extended? There's no simple answers to these questions, but the main message to employers is to be flexible. An employer does not have to wait indefinitely for the return of a disabled employee from leave, so the failure of an employee to provide even an estimate of when she could be back at work was fatal to a ADA claim. Leave whose duration extends beyond the maximum leave period provided for under the FMLA or the Family Medical Leave Act might not be required as a reasonable accommodation. At least for the EEOC, the key issue is whether there's any reasonable prospect of the disabled employee being able to return to work. The reasonableness of an accommodation is distinct from whether that accommodation would impose undue hardship on the employer. An employer can refuse an otherwise reasonable accommodation if the employer can show that providing it would impose significant difficulty or expense in relation to its size, resources, and the nature of its operations. In general, larger employers are required to go further in accommodating disabled employees than are smaller employers. Accommodations imposing undue hardship are those that are unduly costly, extensive, substantial, or disruptive and would require fundamental alteration to the nature or operation of the business. Many accommodations are inexpensive. The Job Accommodation Network puts the typical costs of an accommodation between $500 and $600, but also claims that 58% of all accommodations do not impose any direct costs to employers. Congress, in enacting the ADA, expected that employers would incur some cost and difficulty in opening up their workplaces to disabled persons. Employers claiming undue hardship must produce evidence of significant difficulty or expense and cannot rely on mere speculation about potential costs or problems. One way to convincingly show undue hardship is to try out an accommodation and document the cost and any operational problems. In the process, the employer might learn that providing the accommodation is not such a big deal after all. A variety of tax breaks and grants are available to assist employers who cannot meet the cost of a proposed accommodation. Employers can also offer the disabled employee the option of paying for a portion of the cost that is beyond their means. Religion is not only membership in or affiliation with a particular church, congregation, or denomination. Title VII defines religion to encompass all aspects of religious observance and practice, as well as belief. Unlike other protected classes, religion is not only something that a person is, but also something that is expressed through words and deeds. This behavioral aspect of religion sometimes requires accommodation. What makes a belief or practice religious as opposed to philosophical, political, or ideological? The EEOC treats religious, moral, and ethical beliefs as to what is right and wrong, which are sincerely held with the strength of religious view. Courts have struggled to distinguish between the secular and the religious. Belief in a particular god or deity is not necessarily an element of religion. In fact, atheism and agnosticism are forms of religious belief. To be considered religious, however, courts generally require that such beliefs or practices perform a function in the individual's life comparable to that of religious traditions. The espoused religion does not have to be popular, well-known, or even organized. An individual's own sincere beliefs about what his religion requires, even when these go beyond the formal teachings and requirements of his religion, are still aspects of religious belief and practice and potentially require accommodation. A religious belief also must be sincerely held to be protected. Courts are strongly inclined to accept plaintiffs' assertions about their religious beliefs, at least absent behavior starkly inconsistent with the alleged religious practice. As a general rule, employers should accept the sincerity of employees' religious beliefs and practices and focus on whether it is possible to accommodate them without undue hardship. Religious beliefs and practices can clash with workplace requirements under a variety of circumstances. One of the most common is when an employee's work schedule conflicts with a Sabbath or another religious observance, or if religious practices for wearing particular clothing conflict with an employer's uniform or appearance requirements. Sometimes the tasks required of employees conflict with religious beliefs, like a Muslim ham processing plant refusal to touch pork or a Catholic pharmacist's refusal to speak to customers regarding contraception. Employers are also frequently asked to accommodate employees by allowing them to decorate office spaces with religious items and by providing special meals at company events. Maintaining policies that are flexible for paid time off can prevent conflicts from arising in the first place. Employers are not expected to be aware of the religious affiliations and practices of their employees. To be entitled to accommodation, employees must inform their employers regarding the presence of conflicts between their religious practices and workplace requirements, and do so before disciplinary action is taken. Though employers should listen carefully and be prepared to consider accommodation if they discover that an employee might have problems complying with a policy or workplace requirement for reasons related to religion. The final element of a prima facie case of failure to reasonably accommodate is showing that the employee was subject to an adverse employment action, like suspension, demotion, or termination, because of the following of his or her beliefs. When presented with timely requests for accommodation of sincere religious practices, employers must make good faith efforts to identify reasonable accommodations that do not impose undue hardship. Although a good faith effort to find an accommodation might come up empty, employers are in a better position if some accommodation is offered rather than none. As with disability, a reasonable accommodation of religion need not be the employee's preferred accommodation, but providing the employee's preference should be the first inclination. How far must employers go in accommodating religion? The measures that must be taken to accommodate religion are not extensive. Clashes between religious beliefs and job duties can especially be difficult to accommodate. Accommodating employees' religious beliefs by making exceptions to dress and appearance requirements is often required. When it comes to reasonably accommodating religion, it's advisable to permit scheduling swaps, use of personal time, flexible scheduling, or explore the possibility of lateral transfers that might lessen conflicts. Exceptions should be made to appearance requirements unless doing so would impose undue hardship. The possibility of meshing appearance requirements with religious practices should also be investigated. Conflicts arising from objectionable job duties might require employers to provide assistance in arranging transfers to alternative positions. Employees sometimes convey their religious beliefs to others in the workplace. Often the aim is to interest coworkers or customers in a particular religion. Such religious advocacy or proselytizing puts employers in a difficult position. On the one hand, it is a part of the proselytizing employees' religious beliefs and practices that potentially requires accommodation. On the other hand, employers are obligated to protect employees from religious harassment. The religious advocacy of one employee can be the hostile work environment based on unwelcome, pervasive religious communications of others. Employees whose religious beliefs distinguish them from their coworkers are also sometimes victims of religious harassment. Sometimes it's employers rather than employees who are the ones expressing their religious views. Public employers are subject to the U.S. Constitution as well as to Title VII. This further complicates the handling of religion in the workplace for government agencies. The First Amendment protects the free exercise of religion from infringement by the government, but it also prohibits governmental entities from sponsoring or supporting religion. Public employers must be careful to not unduly limit religious speech and conduct of employees, while also not allowing the workplace to become infused with religious content. If it's illegal to discriminate based on religion, does that mean that churches must hire persons of other faiths and attempt to reasonably accommodate their divergent practices? Title VII contains a religious organization exception that absolves churches of any liability for discriminating on the basis of religion. Religious organizations can limit employment to or have a preference for persons sharing the same faith. This exemption includes not only church activities but also secular endeavors, like church sponsored schools and hospitals, as long as they are nonprofit entities. Moreover, they can facially discriminate in these ways without bearing the burden of establishing bona fide occupational qualifications based on religion. Furthermore, for constitutional reasons, discrimination on other protected class grounds is not contested where ministerial positions with spiritual functions are involved. Although clergy positions certainly fall within this ministerial exception, the Supreme Court said that it also applied to a teacher at a Lutheran elementary school. Because the definition of religion is fuzzy, it should be not surprising that it's difficult to pin down exactly what constitutes a religious organization. However, a court did find that the religious mission of promoting Christianity on college campuses makes InterVarsity Christian Fellowship USA a religious organization, even though it's not a church or other traditional religious organization. The mere fact that the owners of a company hold strong religious beliefs is not sufficient to convert a profit making company into a religious organization.